The first case on our calendar, W.D. versus Archdiocese of Miami.
Good morning, Your Honors.
Good morning.
My name is Scott Henratty with Maylove Henratty, PA in Fort Lauderdale, and I'm here on behalf of the appellant W.D. I would like to reserve 4 minutes for rebuttal if I could.
Okay, when you see the yellow light come on, you will be into your rebuttal time.
Thank you, Your Honor. Justices, this is a case about access to courts. Although it deals with statute of limitations, it's about access to courts for child victims of sexual abuse. Although I am the appellant, Judge Phillips, I think, did a great service by doing what she did to allow this case to come before this court to correct wrongs from cases that I'll discuss out of the 3rd District, with all due respect, that the Cisco case and now, as of last week, the Firestone case are decided incorrectly based on the delayed discovery doctrine set out in Herndon, the Supreme Court case from 2000, the Florida Statute 95.11 paren 7, Florida Statute 95.11 paren 9, which specifically deals with sexual abuse, which the legislature enacted in 2010. The appellant brief lays out 6 avenues for this court to reverse the trial court and allow delayed discovery doctrine to apply to WD. What's important is the delayed discovery doctrine has never been this case of first impression for this district.
So you would say that for us to reverse this trial court, we'd have to certify conflict with the 3rd?
No, sir. I mean, you would, because the Cisco case would have to be, and the Cisco case is the problematic case with the Judge Phillips at the trial level had, and the Middle District judge in the St. John's case had. And I would submit to you, maybe the appellees would appeal that and make it a conflict case, but not necessarily certify it. But just decide the case in the facts and circumstances of this case, where a 6-year-old boy is sexually assaulted and has a repressed memory, and then subsequently remembers in 2013 and then files suit within months, that is a good case and a viable case under the Supreme Court doctrine in Herndon, and again under the 2 statutes if read properly. And I cite to Cisco, well, I should probably go back to Herndon real quick in the certified question that the Supreme Court decided. And they redid the question, but this is what they said, and they affirmed. Where a plaintiff in a tort action based on childhood sexual abuse alleges that she suffered from traumatic amnesia caused by the abuse, does the delayed discovery doctrine postpone accrual of the cause of action? We answer the phrase question in the affirmative, without qualification. And
You would agree, though, that the Supreme Court in Herndon did make a point of limiting it to the facts of the case and limit it to a perpetrator as well.
I disagree with the last part of that, Judge. I do agree that they did limit it to the facts of those cases. I believe the appellees and all the cases that they've been in front of other courts have tried to make that argument that they mentioned perpetrator, but they don't make, if the opinion is read correctly, like question I just read, it happened to be a perpetrator who the stepfather, and there were no vicarious claims in the case, but she didn't have any to bring. She wasn't suing his employer. The crux of the case is, and the crux of the estoppel argument as well is, and the point about Herndon is, you cannot do these things to a child to the point where you repress their memory. And then when they do remember and timely file within 4 years, whenever they do remember, and hold that against them when the defendants themselves are the ones that created this problem. And that's I suggest to you, the holding in Herndon is, the Supreme Court is, we are going to not allow defendants to benefit from that fact. It's a repressed memory case from those actions. Not necessarily that it's a vicariously claim or it's not, or it's against the stepfather. You could take it to the extreme where the Supreme Court said we're limited to these facts. You could take that to the extreme and say, well, we're only limiting it to females, or we're only limiting it to an incest case, which that was, technically. And that's just not what the case says. The Supreme Court, and the idea behind it is, we are going to protect these children that lose their memory and then timely file later. And I submit to you that that's exactly what the legislature did in 2010 when they enacted 9511-9 and said, and the statute is very broad, sexual battery offenses on victims under the age of 16, an action related to an act constituting a violation of subsection 794, which is a sexual battery statute, involving a victim who was under age 16 at the time of the act may be commenced at any time. At any time. And that was before WD even remembered that he was assaulted. So under Herndon, his case had not even accrued yet, which there is, I'm sure counsel's going to get up here and tell you about the caveat to that section is, this subsection applies to any such action other than one which would have been time barred on or before July 1st, 2010, which, if you didn't have the delayed discovery doctrine set out in Herndon, would be problematic for WD. But again, getting back to the fundamental principle that a 6-year-old who has no memory cannot tell an adult, cannot bring a cause of action until he remembers later, his case has not yet accrued. And Herndon gives a nice discussion about the difference between accrual and told statute of limitations.
I guess the big question for us is whether the philosophy that you're espousing that came out of Herndon, which is that you can't prohibit access to a court for someone who doesn't remember because of the abuse that was inflicted, applies to anyone other than the perpetrator. I mean, I get it. I mean, it's pretty clear in Herndon. They say, well, when it's a perpetrator, we're not going to let that person get away with it. But when you go beyond the perpetrator, then does it matter whether it's a respondent superior? Does it matter whether there's direct negligence on the part? Does it have to be some intentional act on the part of somebody other than the perpetrator?
I think we can look at two places for that. Is the public, in the brief at page 25 and 26 talks about public policy reasons behind this, and the reason we have respondent superior claims and the reason we hold employers liable, because it's safer for everyone and it makes people responsible, and that's why we have those claims at all for any reason. So there's good public policy reason behind having those claims, but why not have them for sexual abuse cases? Don't children of sexual abuse need more protection than the driver that's driving the car down I-95 for their employer? So there's no reason not to, logically, to protect children for responding on superior claims when we do it for every other tort, if you will. And I would go, and maybe more telling is that the legislature in enacting 9511 per in 9 says any action related to any act. So doesn't our own legislature want to make it as broad as possible? And the appellant brief does discuss the legislative history where they do discuss Herndon and the delayed discovery doctrine and the philosophy of keeping the courts open to these kinds of things that I'm expounding on. And I would like to point out too that I'd like to touch on two things briefly. That the trial court dismissed this respondeat superior claims against the church and the state, the church and the school. And I would submit to you that they had the exact same statute of limitations arguments as the perpetrators themselves, which the court did not dismiss. The claims are exactly the same, except they want to hold the employer liable for the acts of its servant. So those cases should not be dismissed on that alone. Secondly, the count 1 and count 4 are intentional tort claims, intentional infliction of emotional distress against the school and the church. And those claims are intentional acts, and under 95.117, the older statute of limitation argument, where there is some confusion about the language, and I talk about in the brief about how a good textual reading of that, reading based on and focused on that, a good textual reading will let other claims be brought, but those are intentional acts. It's an intentional claims, and those should not have been dismissed based on that alone, that they were intentional. They're intentional torts.
I'm sorry, what are the intentional torts?
The intentional infliction of emotional distress claims. So
By the school.
By the school and the church, counts 1 and counts 4 were dismissed. And those intentional acts being, as alleged, moving around the priest to prevent prevent discovery of the crimes, destroying documents, intentional things that they were doing that were inflicting distress on the
Sorry,
child.
I can't recall, in the complaint, did it talk about that these three priests were moved about after the acts?
It does allege that. It does allege that. It alleged that the church bought the mother a home, a house, with a deed to the house. It alleges at that same time when the house was bought for the mother that one of the priests was transferred from his position right around that time. So it does discuss those allegations. Yes.
I think it speculates that the church bought the home, right? There's no direct proof other than the fact that as I recall, the complaint says unlikely he could have afforded it. They don't have any proof that the church actually paid for it directly.
Two things, Your Honor, I would say to that for the purposes of the motion to dismiss, that all the allegations need to be deemed true. But I can tell you that we do allege, we do have the deed, and the deed does not have the church in all candor on the house. It does have the priest, and it has the mother's name on the deed. And then we do talk about the finances and what we believe the finances to be. So we do discuss that. But I just want to briefly the equitable estoppel claims, which if we didn't have any of this, and it goes to back to that same principle that you cannot drive a 6-year-old into a state of amnesia and then benefit from them. The 4th District Court case, the Florida Department of Health versus SAP, where a 4-year-old was sexually abused, and then the department tried to take a benefit from that, and this court said no. The Supreme Court affirmed, and just a matter of equity, and it's just something that should not be done in a civilized society. I'd like to reserve. Thank you.
Thank you.
May it please the Court, Elaine Walter of Gaby, Mullen, Antonelli, and DiMatteo on behalf of the Archdiocese entities and St. Bernadette Home and School.
Let me just say this. I would suggest to you that, but for subsection 9, you'd be in really great shape. I'm a little concerned about how that affects the claims.
Okay, then I will
So let me have you
start with
focus on
subsection
that.
9. Subsection 9, by its terms, is limited to cause of actions that accrue on or after July, I believe, 1st, 2010. We have no problem with that. So anything that accrues on or after July 1st, 2010 is fair game, no matter who it's against, whether it's the perpetrator or the employer.
So you think it does open the doors for anyone after that date?
As long as the cause of action
Accrued
after that date.
And when did this cause of action accrue?
This cause of action accrued at the latest in 1997, when WD, 4 years after he turned 18. And the reason for that is, even under the delayed discovery doctrine, I want to make sure that I get this properly out there. Even under the delayed discovery doctrine, let me make sure I go to my notes. Under Herndon, there's no saving cause of action because this cause of action was against the church, not the intentional tortfeasor. If we go through the Herndon analysis, Herndon was limited by Davis to the specific allegations or the specific facts of that case. And the specific facts of Herndon were the perpetrator of the abuse, not any institutional entity. So that does away with Herndon for purposes of the delayed discovery. So we can't rely on Herndon to delay the accrual of the cause of action to help with subsection 9. So then we go to subsection 7 to see if that helps with any sort of delayed accrual. Subsection 7 speaks to intentional torts based on abuse. So the only thing we have to deal with that's been alleged here, there was negligence, intentional infliction of emotional distress, and respondeat superior. So we have the intentional infliction of emotional distress count. But if we look at the terms of subsection 7 and the citation to which statutes and the definitions of abuse, if we look at all of those definitions of abuse in 39.01 subsection 2, and I need to make sure that I'm telling you all of the right statutes. I know you can read them on your own.
I think that
They-
one's the only one relevant of the three.
But if you read them all together, they all speak to actions of individuals and not to institutions. Because also within 3901, there is another subsection, subsection 32, that is institutional abuse. And that's not included within subsection 7. Subsection 7 doesn't cite to it. And even, now at the time it was promulgated, it wasn't there. Even when it was added, subsection 32 was added in. It wasn't by the legislature placed into subsection 7 to say, yes,
What was
we
the
are
date
looking.
that the WD is alleged to have become aware of the sexual abuse?
2013.
Okay, so that's after 2010, correct?
That is correct.
So why didn't his cause of action accrue then? In 2013 instead of 2010, which would make subsection 9 applicable.
Correct, because he had to have had some legislative mechanism or some common law mechanism to delay the accrual of his cause of action. Delayed accrual is only by statute, according to the Florida Supreme Court. And that, under Herndon and Davis v. Monahan, is medical and professional malpractice, fraud, intentional torts, and there is one other that is escaping my memory right now.
I thought you started this discussion with, you agreed that any cause of action that accrued after 2010, subsection 9 applied to and would allow for the claims that we have here.
Correct. But WD's cause of action cannot accrue after 2010 because it is barred because there is no mechanism for delayed accrual for him, because he can't get a delayed accrual through any mechanism other than a statutory provision. And there's no statutory provision that permits delayed accrual for his cause of action.
So you're saying that if somebody was abused today and then repressed it for 40 years, that they could use subsection 9 to get around any kind of limitation
They
that
can-
would be
they-
imposed by 7.
They cannot. They can only use it if their cause of action, okay.
In that case, in that hypothetical, it would accrue.
Say someone was abused in,
2008.
2008, and the numbers aren't coming to my
And
head.
then missed,
But
waited
they,
10 years.
they
because of
missed it,
repressed.
but they have a window then because their cause of action didn't, if they were a minor in 2008 and they became of the majority in 2014, they can bring the action at
And
any
your
time.
theory is supported, in response to Judge May's question, your theory is supported by the Firestone case, right?
It's supported by Cisco, it's
like
supported,
identical
well,
to this
that
case in
didn't
terms
have.
of the years.
Yes. Neither of those cases, however, had a claim for intentional infliction of emotional distress. However, if we do look to the case, your case, that was Doe versus Sinrod, Doe versus Sinrod looked at a question of an individual, a claim of intentional infliction of emotional distress against
School board.
a school board. And this court said you only get intentional infliction of emotional distress against the individual perpetrator.
Well,
It only
except
applies.
that went on more on sovereign immunity.
I agree with you, Your Honor.
So it was somewhat dicta.
It was somewhat dicta.
Statement.
The statement is in there, but the analysis was also there to look at the two statutes and compare and contrast them. The statement is there. We did rely on it.
But there's
But-
really nothing in any of these statutes, well, particularly in 95.11.7, that specifically says you can't use that against an institution.
Unless you look at those statutory provisions that define abuse and see what's in those statutes, and those statutes don't refer, they refer to individuals committing abuse. and I have the actual phrasing if you'd like me to go through it with you. It might be very boring. I know you can read it yourselves. But it refers to caregivers. It refers in some of those provisions. It refers to things that are committed on the individuals who are abused. It doesn't refer to something that an institution has done.
Well, do you argue that by virtue of the fact that that statute is framed intentional tort, and that intentional tort means intentional tort, you can't throw in respondeat superior?
I think the respondeat superior issue is covered by subsection 9 in the legislative comments when it was enacted. And the comments in the legislative history say now we have this enactment is designed so that you can now bring a claim for respondeat superior against an employer. And I think that is intended to fix anything there was, if there was not a claim for respondeat superior, and that's where that lies, and now that's where that belongs, is within subsection 9. And the legislature was trying to fix a problem. If there was a problem in the first place, that's where that claim would lie, was in subsection 9.
Did subsection 7, was that enacted after Herndon?
It was enacted almost simultaneously. Ms. Herndon filed her complaint in 1991, I believe, and subsection 7 was enacted in 1992.
Okay, so it wasn't a reaction to Herndon.
No, actually the court said we wish we could rely on it, but we can't. Any other questions? Okay, I do have a couple of other things, if that's okay, since I
Please,
have
you've
a
got
few
5
minutes
minutes.
left. Okay. Opposing counsel mentioned the Dobe versus St. John Episcopal Parish Day School and the statements in there wherein the court decided that Herndon and Cisco were not necessarily dispositive, and the judge found that the vicarious liability claim not to be time barred, and the judge relied on Herndon and Cisco because vicarious liability is not a claim directly against the perpetrator, and the court relied on 2 second DCA cases that simply stated that the statute of limitations for professional malpractice for a physician also applied to plaintiff's claims against the employer. But what I wanted to point out that nothing in those cases provided for the application of delayed accrual to delay the accrual of the cause of action against a non-intentional tortfeasor employer. So I just wanted to make clear that I'm not sure that case is 100% on point. And the cases that were cited to are Arthur versus Unicare, which is 602 Southern 2nd 569 or 596, and Shields versus Jack Eckert, which is 560 Southern 2nd 361.
So you would agree that if we were to apply the Doe case, the St. John's case, to this case, we'd have to reverse the trial court? I'm saying if.
Oh, no, I don't. I don't think so at all. I think that court got it wrong.
Right, but if we were to say that it got it right, it's...
If you're going to say it got it right, yes. However...
But you're saying it got it wrong.
I think it got it 100% wrong because it applied cases that were not looking at a delayed accrual issue. Where here, we're looking at the regular statute of limitations, the 4 years, and then you have to find something else that gets you further than that. And that's not what that court did.
Let me take you back to the recent decision in Firestone. I see you're the lawyer on that as well. Third District didn't spend a whole lot of time analyzing this. They kind of just went to the point and said what they said. So in your argument about why subsection 9 doesn't save this claim, you're saying it's because the cause of action had accrued earlier, 4 years after WD turned 18, and the tolling provision didn't apply, or there was nothing to toll it until later on.
Correct.
Is that correct? Because when the third district talks about subsection 9, I mean, it's really only not 2 sentences. So it just says, without reaching the issue of whether the provision covers the theories we note the provision does not apply to causes of action that accrued and would be time barred on or before July 1, 2010. Well, that's what the statute says, so that's not too hard to figure out. And then it's because the claim would be barred, it was correct for the court to find it didn't come in. But it gives no analysis to it, it just says it.
Right, well, and the claims in that case were breach of fiduciary duty and negligence, and respondeat superior were the three claims that survived. And I think the plaintiff dropped the negligence claim on appeal, didn't raise it. And the court, we went through a Herndon analysis, a Cisco analysis, very similar to what we're doing here, and argued that Herndon didn't accrue, didn't delay the accrual of any of the claims. And therefore, I believe what happened was the court said, without any delayed accrual through Herndon, there's
Yeah,
no
you'd have to
saving.
read a lot in there because it's
Yes,
not there.
I know, it's not there. That was the argument that was made.
Okay, so there were no intentional
No.
torts pled in that.
No, just a breach of fiduciary duty would be as close that would come to an intentional tort.
And so, does that somehow distinguish this from the third district's decision in Firestone?
I think that it could, Your Honor. However, I would go back to the analysis I have given you in our brief and tried to hear that the intentional tort in subsection 7 was meant for the actual perpetrator of the abuse. And if I could just touch on the estoppel argument before I
Sure.
completely run out of time. This court has said that equitable estoppel is not available when there are also repressed memory allegations, and that case is Ryan versus Lobo de Gonzalez, which is 841 Southern 2nd at 520. There, the mother was not aware until well after a cause of action had accrued. This is not a child sexual abuse case. This is totally unrelated, and therefore she was not reduced to forego filing suit until the statute of limitations period. I think that is a very on-point case with very different facts. But otherwise, one party has to lull the other party into a disadvantaged legal relationship. Clearly, based on the facts, the Archdiocese did not do that here, and if that would have happened, based on the house being deeded, the house was given back to the priest in 1991, so there was a time period where there was no undue influence, if there was any in the first place, and a cause of action could have been brought. But because there was no memory, I find it very hard to see how equitable estoppel would apply here in the first instance. And I think that does it for me, and I am out of time anyway. Thank you. We would rest on our briefs and ask that you affirm.
Thank you. Thank you. Would you agree if we find Firestone controlling that this is an affirmance?
Judge, I believe that the Firestone case and the Cisco case are problematic, and yes, and I agree. And that's why, I think that's why we're here. I think that's why Judge Phillips struggled, and that's why the Middle District Court struggled in St. John's, there's a lot he talks in there about, I have to go with Cisco, I really don't have much else, it's kind of binding on me. But it almost seems like he didn't want to.
And then he wiggled out of it.
And for those reasons, if you look at Cisco, and if you look at both opinions in the Firestone opinion, they're less than 2 pages. And even in the Cisco case, the last sentence says, quote, although the appellants make compelling arguments, we conclude that the requested relief is a matter for legislative consideration. This is a 2013 opinion. Subsection 9 is enacted 3 years prior to this and is not mentioned in this opinion. That court does not even address what the legislature had done 3 years ago, which they're begging and asking for. And how can we give credence to that opinion, again, with all due respect to the third?
Why did the legislature cut out people like your client by putting that time date?
Judge, they did not, because I think they cut out people like Sinrod, they cut out people like Dorsey, they cut out people like Rubio, all cases that weren't repressed memory cases, where they had told their parents, or there was some cause they could go to the court. They had access prior to where the statute was running. we're ignoring Herndon. And Herndon, in reading it carefully, it is one single perpetrator. But the court's certified question, and when they go, we conclude, they don't mention the word perpetrator or that specific person. The fundamental principle is that same public policy reason is we want to keep the doors open to somebody that this happens to. And if you read Herndon and read subsection 9, WD has a cause of action, and frankly, everybody in the state of Florida who is sitting there and has repressed memories and their claims are 20 years, 30 years, 40 years old, they still haven't remembered. If we say that they don't have claims, surely the legislature did not intend to limit anybody who has this happen to them that hasn't remembered yet.
But when you, your theory is very laudable that if someone causes the repressed memory, therefore they couldn't have had the cause of action accrue because the very acts that created it prevented the memory. Wouldn't that limit the cause of action as to who it could be pled against to the person who actually caused the repressed memory? And I mean, your point is, someone who does something so badly that causes someone's memory to be repressed shouldn't be rewarded because time runs. There should be a tolling provision until against the person who caused the repressed memory.
Correct.
So would it have to be only the person that caused the repressed memory for whom the tolling applies?
No, because in restatement of torts, we have vicarious liability claims in all actions. So why there's no logical reason to limit it to just the perpetrator.
Go ahead.
There's just one sentence, and it's not a sexual abuse case, but in the Supreme Court case of Davis versus Monahan, there is a sentence in, if I can give you the exact date, 710. It says, although the legislature did not specifically provide for delayed accrual, we reasoned that in the narrow circumstance of lack of memory in childhood sexual abuse cases, the doctrine was appropriate because the lack of memory was caused by the abuser, a situation similar to the statutory circumstances to which the doctrine applies. So here it was a subsequent Supreme Court case limiting it to the abuser, not the abuser, the abuser's employer. I'm having a problem with that. I'm stuck on that because I was looking, I thought I had seen one. I know you said in Herndon they didn't actually say only the perpetrator, but I knew I'd seen it, and that was, I believe, where I had seen it, that a subsequent Supreme Court case seemed to imply that Herndon was limited to the perpetrator only.
And if we I would say just a close reading of Herndon and the question that they certified and they unequivocally answered in the affirmative, and when they conclude, doesn't make that limitation. And I have page 25 and 26 of the appellant brief goes through the logical reasoning of not limiting vicariously.
You don't think that sentence I just read to you, talking about Herndon, the Supreme Court talking about Herndon?
And I think the Davis case is not but the Davis case is not a repressed memory case.
That is true.
In which the other cases are not as well, that the Fourth has been in front of, which makes all the difference in the world, and that makes all the difference in the world to that statute. Thank you.
Thank you. Appreciate your time.
Thank you very much.
Yeah.